SJC-13026, Cassouto-Noff and Company v. Amy Diamond.
Hi, Mr. Valicenti.
Good morning, Judge. Thank you, David Valicenti, on behalf of the appellant, Amy Diamond. I'd like to start by discussing the question of whether in the second paragraph of the Recognition Act, whether there's a service of process requirement. And we have argued that there is, because the language of the statute includes the words personal jurisdiction. And personal jurisdiction, as it's understood, certainly in Massachusetts and generally, includes a couple of components. First, it includes the component of a basis for jurisdiction, but it also includes the component of acquisition of jurisdiction. And acquisition of jurisdiction requires service of process. The way that it was stated in the Wang versus Niakaros case was in the reverse, but essentially that personal jurisdiction over a defendant cannot exist without proper service of process or an appropriate substitute. And that's the reason that the law that we applied to this set of facts started with the Wang case. And the lower court held that there's no Rule 4 service of process requirement in the statute. However, what Wang says is
isn't that correct? Isn't that right, though? I mean, it has its own notice provision, the statute. And we tend to associate notice with due process and jurisdiction. So isn't the trial judge right on this, the motion judge right?
It's correct, Judge, that the statute does not indicate that Rule 4 needs to be applied. But if we accept that personal jurisdiction includes acquisition of jurisdiction, my argument is that either service of process under Rule 4 or a reason why you didn't serve under Rule 4, which I think is generally consistent with
the Israeli court found there was adequate service, correct?
The Israeli court found the Israeli court indicated that there could be service by mail, which didn't happen. And the Israeli court ultimately indicated that there was evasion of service. I believe that was the reason that they decided that service was not needed. And I would say that that's consistent with the Wang decision. Wang would say that if you had knowledge and you evaded, we would consider that a justification for non-service.
But didn't the Massachusetts
Don't we have that
court,
here?
Sorry, Justice Schwartz, go ahead.
I apologize, Justice Castro. Don't we have that here? Where there is notice and arguably evasion?
We have a finding of notice, which I will deal with, a finding of knowledge, but the lower court found no evasion. The lower court found very specifically that there was no evasion and indicated that at page 36 of the record that that he believed that she had knowledge of the suit, which I will discuss, but that she was right, that the defendant was right, that she did not have to go upon receiving a phone call from the sheriff and asking for the sheriff to meet with her, that she had no obligation to go and meet with the sheriff. And so,
aren't we skipping a step, though? Don't we have to start out putting the due process issue aside for a moment? Don't we have to start out by determining whether the law of Israel or the law of Massachusetts applies as it relates to personal jurisdiction?
we can start there.
But I'm just asking. I want to make sure that I'm in the right place. Before we get into the details of what's required for personal jurisdiction and what the impact is of the Israeli magistrate's findings, don't we have to do an initial step as to what law applies?
In the initial step of what law applies, I would say in this instance, Your Honor, either test that you would apply, whether you adopt the test that you would apply both laws or you adopt the test that you apply Massachusetts law, I think in this case, the court should be applying Massachusetts law ultimately, and that's the way we approached it. And so this court may decide that it's going to adopt one test or the other or some other approach, but ultimately, I don't think there's any disagreement that the trial court in the end needs to apply the law of the recognizing jurisdiction in order to decide if personal jurisdiction was met.
But isn't it obvious that even under our choice of law, if we're applying our choice of law, we're going to end up with Israeli law here. All the action takes place in Israel. I mean, Massachusetts has, you know, she's chosen to do, your client's chosen to do business in Israel. She actually appears for the litigation. Why would we not find Israel the appropriate jurisdiction?
Because the way the case law is developed around the Recognition Act, and I will say there's not a lot in Massachusetts, but typically a choice of law analysis, I think the type to which Your Honor is referring, is not employed. Instead, what the court says is, in Evans' Cabinet and other cases, we will apply the law of the foreign jurisdiction to see if there was jurisdiction, and then we will apply the law of Massachusetts as a check to make sure that that's sufficient. So I don't think you land up, Your Honor, with one or the other.
Is that right? Or we apply, we do it's not exactly the same choice of law analysis, but we look to see whether what's the appropriate jurisdiction under the Uniform Judgment Act. And then we do a constitutional due process analysis consistent with how we do it here, but we do that to double check. But I don't think we are applying Massachusetts law to that. We're applying sort of principles that do a choice of law analysis up front, as Justice Lowy was talking about.
Well, the position we've taken is that that the court should apply Massachusetts law. But I would suggest that even if the approach that Your Honor is suggesting is correct, if that's how the court ultimately goes, that when you get to the question of due process under Massachusetts law, you effectively are looking at what the Wang case lays out, right? I mean, because the question of due process, while it may not require Rule 4, Rule 4 is a part of due process. It certainly illustrates at least one way in which due process is satisfied. So I mean, I think all these concepts are important, but in the end, the lower court, I believe, should have been checking to see, was there service of process, or was there a good reason why there wasn't service of process?
Do you agree, counsel, that your client had at least the minimum contacts required under the traditional constitutional analysis for personal jurisdiction?
Yes, we have not contested.
So your issue is really only whether or not service was sufficient.
Absolutely correct. We were not contesting.
So I guess, given that you're not contesting that there was minimum contacts for purposes of assessing personal jurisdiction under our Constitution, meaning the U.S. Constitution and or Massachusetts Constitution, why don't we then apply the due process notice requirements of Section 23A, which just requires that your client receive notice of the proceedings in sufficient time to enable her to defend?
So first, Justice, I would say, when you look at how the minimum contacts rules are applied, you notice that even in the lower court decision, they apply the long arm statute. They do look for an authorizing statute under Massachusetts law and then turn to the constitutional requirement. But, and I think the same thing should be done as it relates to service of process. But to answer your question about why not just the notice provision in the statute, the notice provision is not the provision that governs service of process. And the reason why I say that is that
no, but the statute doesn't require service of process. The statute just requires that there be personal jurisdiction. And then in terms of notice, it requires what I quoted before.
It says that, but the Model Act on which this is based, right, has the same language for what we have in paragraph 2, which is personal jurisdiction. It then has the same language in our paragraph 3, which is the notice provision. However, in the Model Act, in the drafters, that third group, including the notice provision, was non-mandatory. It was discretionary. In fact, the way it read was a foreign judgment need not be recognized. And so in the drafting of the Model Act, if the notice provision was discretionary, that means that the way that they laid it out meant that service of process must be somewhere else, or else the statute wouldn't have required any notice. Right now, I understand and accept.
I'm confused by what, can you be more specific? What are you talking about? I have no idea what you're talking about at this point.
So the Model Act has the same paragraph as the third paragraph in the Massachusetts Act, which starts with a foreign judgment shall not be recognized if
Yeah.
defendant did not receive notice. The way the Model Act was drafted, it said a foreign judgment need not be recognized. It was non-mandatory. The way the Model Act was.
All right. And so what are you suggesting that means?
I'm suggesting that means that the language of the statute and the notice provision, if it was non-mandatory, that does not cover service of process. That service of process must be somewhere else. There must be some other notice that's required, and that would fall under personal jurisdiction, or else you wouldn't have a notice requirement in the statute.
But
You've
counsel,
got two-
if there were another notice requirement, wouldn't that be spelled out somewhere, like what it was?
It's not spelled out.
Right, but doesn't that suggest there's nothing else?
I don't think that it suggests there's nothing else, Your Honor, because of the fact that personal jurisdiction and the way that we have generally interpreted it includes it. And that's fairly common.
Is there anything other than Wang for that proposition that personal jurisdiction in the way we've interpreted requires this service of process in the way you're suggesting Rule 4 requires?
Well, I think
Because
that-
usually, I mean, back to law school, right? Personal jurisdiction is just all about minimum contacts with the particular jurisdiction. Now you're overlaying on that a due process requirement about being notified about the proceedings, but that usually in law school is separate and apart from personal jurisdiction.
I think that I think there is support for the concept, not only in Wang, but in the decisions of this court and in other courts, that personal jurisdiction consists of the second step that I'm suggesting, which is acquisition of personal jurisdiction. That acquisition of
So personal jurisdiction requires acquisition of personal jurisdiction.
Yes.
That's your proposition.
It is.
Okay.
It is that there's a basis for jurisdiction and there's
I just don't-
acquisition.
I don't understand why, even if we think we're bound by Wang, which we're not, but Wang is a case, it's a Massachusetts case. It's a pure Massachusetts case. It says you need service of process to have personal jurisdiction. We've got a totally different kind of case here. There is service of process. It's done in accordance with Israeli law. So even this case is consistent with Wang in the sense that, okay, you need to satisfy service of process according to the appropriate form. It's done here in accordance with Israeli law. And Wang is a case where in a pure Massachusetts case, you need service of process according to Massachusetts law, but this isn't a pure Massachusetts case. You're just putting a lot of weight on a little, I just don't see why we're bound by this, and it's clearly distinguishable to me.
Well, I'd like to spend some time then, if I may, Judge, on the facts of the case, which are that.
I'm sorry to interrupt. I'd love to hear an answer to Justice Kafker's point, because if we merge service of process into personal jurisdiction in the statute, the whole point of the statute is that a foreign country is supposed to be treated like a sister state. And you don't expect, if you want to enforce a judgment, that you have to know the idiosyncrasies of 50 different states as it might relate to service of process and long arm statutes. So it's sort of hard to, I understand we've, maybe it's, we got a robust repugnancy clause, we have a due process overlay, but let's not just skip Justice Kafker's point. We don't have anything that says in this context that we are weaving in, fusing service of process into our personal jurisdiction analysis.
Well, but I would say, but we certainly have to infuse our due process analysis,
Okay.
right? And so with the due process analysis, we know papers are never delivered to Ms. Diamond. We know they know where her residence is, but they don't leave the papers there. We know they know where her residence is, but they don't mail her anything. And, the Mullane case from the Supreme Court said, it's about, are you desirous of conveying notice?
We've got to find.
She ducked them. They called her and she ducked them. Her husband said, "No, get away. We're not going to accept these papers."
Well, they asked her if she would meet. The record says, "Will you meet us?" And she said she wouldn't meet them. But then they don't go.
The deputy sheriff has a telephone conversation with her, correct?
Correct.
She's clear. I mean, you can argue whatever you want, but she's clearly ducking service.
That the lower court didn't find that she was ducking service. They found no evasion, but they found notice. But they found notice based on the fact that the Israeli law firm had been sending letters, and the fact that then she got this call from the sheriff, which those two things were 8 months apart, right? I mean, and there were other creditors that were out there. There was no meaningful information from the sheriff on this record about what the suit was about, by who, where it was, or any of that information.
But I don't. She knew what it was about. They had sent her emails saying, "Here are the bills. You promised to pay the bills. You haven't paid the bills." They sent her notice that they wanted to enforce the arbitration clause, all to the same lines of communication that they had throughout this transaction. No response, no response, no response. I mean, can you really argue that she had no idea what this law firm was looking to talk to her about?
I would not argue that she didn't know that this law firm was interested in pursuing her, as were there many other creditors with $1.6 million of debt that came out of this venture. But that last communication is on August the 5th of 2014. It isn't until 8 months later that there's a call from the sheriff. There are lots of creditors, and the sheriff calls and says, "I'm trying to serve you." And she says, "Look, I'm not going to meet you to serve." I think the lower court improperly puts those two things together and then says, well, she knew about the Israeli lawsuit. I don't think those things go together. I agree that she knew that this creditor and probably many others were interested in recovering money from her. But the point is, was she given notice in a way to notify her of the pendency of this action? Did she have the quality of information? On this record, she did not. She did not. And to deal with the issue of how the judge decides, oh, well, you knew about the Israeli lawsuit. I mean, he only really takes that from her answer to the cross-examination question of, well, at some point you knew about it. She didn't know, she couldn't say when. At some point you knew about it. And when she received the package of documents in the Massachusetts action, that's on 385 of the record, is when she said, yes, when I got this lawsuit in Massachusetts, I obviously knew that there was something going on in Israel.
So is that finding that she knew about the Israeli lawsuit, is that a factual finding to which we defer to the judge who saw her, assessed her credibility? Or are you suggesting that's something that we review de novo?
I look at this as a situation where the wrong standard was applied and that the court can review a finding under the Recognition Act as a question of law. But I would suggest even if it is a factual finding, that it is error. That if you look at all these facts, that the judge went too far and took too big a leap in saying that you got a phone call and that's enough. And the reliance on the Olivo case to suggest that, oh, well, that's inquiry notice is where we're going with due process, that you got a phone call, and so now you need to go find out information about that is a leap too far, right? That's not what Olivo stands for, I don't think. And it's certainly, I don't believe, where the law should be on due process.
Okay, I'm gonna see if anyone has any further questions.
Yes, thanks, Chief.
Thank you so much.
Thank you.
Attorney Richmond. We can't hear you.
You're muted, counsel. Thank you.
Thank you very much. Good morning, Chief Justice Budd, and may it please the court. I appreciate you allowing me to come in by Zoom today. I come back to a quotation or a paraphrase in our brief from an old Judge Cardozo case. And I was tortured with Judge Cardozo cases in law school, where he talks about the fact that we're not so provincial here in our country or in our location to think that somebody in a foreign country or another place does it wrong just because we would have done it differently. And I think what I'd like to focus on is the fact that for the Amy Diamond's arguments, and my and my brother has worked very hard, but Amy Diamond's arguments are for the most part just contesting or debating or criticizing Judge Agostini's findings of fact, which have to be given great and tremendous deference. This was a case, believe it or not, where the parties originally, if I'm right, filed cross motions for summary judgment on many of these issues, which were denied. And we had a trial on the merits. We had a witness come in from Tel Aviv. Amy Diamond testified, and the judge heard all of the witnesses, and he made factual findings. And at the end of the day, I mean, it's very clear, and it resonates in his lengthy decision in many places where he believed and found, as a matter of fact, that Amy Diamond knew of the Israeli lawsuit. She knew of the arbitration, and she made the decision not to go to Israel to defend it. And at one point, he even says,
did he make, in his fact findings, did he find that she ducked service of process? I can't remember how Judge Agostini decided that point.
You know what, Your Honor, it's a good question. I don't really remember, but what I do remember is that he made a factual finding that it was important to the Israeli judge who entered the default judgment and who had made a finding that she had evaded service.
So he piggybacked on the Israeli judge's finding on that point.
That's correct, because these were all factual findings, because Shmuel Cassouto, when he testified at trial, he told the judge the entire story from beginning to end, which included a complete description of all the procedural steps that his law firm took to get to this particular point.
Well, counsel, can I ask you a question about that part?
Sure.
To Justice Kafker's question about piggybacking off of the finding of the Israeli court, was that error? Because isn't it true that the way that the Israeli court said to effect service, they never did it they didn't comport with that?
I don't think that was error, Judge, because there's a fee agreement between the parties which states that the relationship between the parties is governed by Israeli law, that Amy Diamond consents to that Amy Diamond consented to the exclusive.
Sure, I'm getting to the specifics about the service though. When the law firm said to the Israeli tribunal or magistrate that we can't serve her, and they said, okay, well then you can serve her in this way. And they didn't serve her in that way. So if the Israeli tribunal makes a finding, or that the judge here relies upon that she had notice, is it error when he relies upon that and there was never service in the way the Israeli tribunal said to effect service?
I do not think that's error, because I think under the law and under the act, I think that the judge was to give deference to the finding of the Israeli judge. Plus it was I'm sorry, I'm tripping over my words, Judge. Give me 1 second to try to figure out how to phrase this. At the same time, Your Honor asked a very good question. Judge Agostini also made findings that she knew about the Israeli lawsuit. So even if the Israeli judge states that she was evading service of process under Israeli law, under the Israeli rule, under our act, we met the requirement, according to Judge Agostini factually, to notify her of the proceeding. So the burden really was on Amy Diamond to go to Israel. And while this might be, as my father used to say, more interesting, she had ample opportunities, keep in mind, that Judge Agostini found, because she got bills, she got emails requesting payments, she got notice of the arbitration, and she ignored all of it.
Can I ask you, do you think the act requires service of process? I understand the act doesn't require service of process consistent with Massachusetts law, but does the act require service of process consistent with Israeli law, or is it just a notice?
I think it's notice, Judge, and a good portion of my practice, Your Honor, consists of construction litigation. And I'm constantly running into the Bloom South case, which is a mechanics lien matter, but that talks about, you have to, when you have a statute, you read the statute and you follow the rules of the statute. And all the statute says is that she be given, notice such that she has time to defend the claim. So
Just a little weird to think notice without service. I mean, it may be right,
Yeah.
but it's just odd in our law to not require some sort of service of process compliance. Yeah.
You know what, Judge? And I think, I'm going to be candid with you. Constitutional law is not my bailiwick. I'm not a constitutional
It
lawyer.
is today.
No, it is today. It is today, right? Exactly. But I can tell you that my brother, as hard as he worked and wrote a great brief, they don't cite one case that says that under other states which have adopted versions of this act, that it requires service of process under the local rules of civil procedure. And there are cases that we cite in our brief where judges, I think it's.
Can I shift you, Mr. Richmond? Because I'm actually more concerned by the second issue than the first. I'm not sure it's concerning, but these are big boys and girls, and we're breaching corporate form here. And I understand your argument to be essentially Israel has its own way of breaching corporate form. It may be different, but it's good enough, and it was breached here. But that makes me a little nervous. So tell me why we should allow this suit against this woman as an individual, as opposed to as a representative of the corporation.
So I just want to make sure I understand the question, Justice Kafka. Are you asking about the finding of personal liability? Is that what you're asking me about?
There's a whole issue. Yeah, we're lifting the corporate veil here. And in a case of international business, that's a big deal. If other countries aren't respecting our corporate law, that can become more problematic. Particularly, these are all sophisticated people. We're not dealing with individuals who don't know the business world. So go ahead, tell me why we should respect that part of the decision.
So I don't think there's any dispute as to the manner and way in which my client's fee engagement letter was signed. However, there was testimony at trial by Shmulik Cassouto, who the court found was a seasoned Israeli lawyer, who explained the fact that in Israel, the law of guarantee is such that it does not require a writing like it does here in Massachusetts. Mm-hmm. And Judge Agostini found on multiple occasions, and he even says that he gives credibility to Shmulik Cassouto's testimony that Amy Diamond promised to be responsible for these debts personally.
But I thought this wasn't a personal guarantee decision. It was again, a lifting of the corporate veil.
I think it's both, Judge. I think when I read the decision, I read it both ways. But at the same time, how do I explain this? At the trial, the issue of her personally, when you read through the testimony of the trial, there was a lot of testimony about the fact that she had promised to be responsible. And that's one of the things that Judge Agostini hits on. But at the same time, I think he very carefully, in his decision, makes a number of factual findings, I think, to give comfort that number one, Israel treats lifting the corporate veil very seriously. As a matter of fact, one of the things that's in the trial, and I think it's in his findings, it was in the trial, it's in the trial's transcript, is that Shmulik Cassouto explained how before they could even get to the point of serving Amy Diamond with papers outside of Israel, they had to explain to the judge why they were making a claim against her personally. But Judge Agostini recognized that we do not have the corporate shield doctrine in Massachusetts. He pointed to a whole bunch of factual instances and made factual findings of her undertaking certain activities and business in Israel. And interestingly, he came up, actually, I don't even think this was argued at trial, but he came up with this argument in his brief. It's a great point, which is that her efforts were entrepreneurial. and that under the law of the Commonwealth, certain entrepreneurial efforts can establish, personal liability, and especially.
By the way, is there any support for that? I mean, it's creative, and I understand he references Magellan, but is that? I mean, business is entrepreneurial. I'm just not sure I understand that distinction.
I think what the judge found of import is the fact that there was testimony in the trial that but for the ownership of these exploration, I'm going to follow for purposes of this hearing, these exploration rights, these options to look for energy in the Med. These companies had no assets. They had absolutely nothing. And in fact, as a footnote, Amy Diamond had testified that it was her quote intent to pay them if the exploration was successful. Putting all that together, the fact that she was entering as an experienced person, she was entering into a field of business which is very, very risk heavy. That he looked at that as being entrepreneurial. But I think that we have.
Again, are there cases that adopt that? Because that's why you have corporate form, to protect your personal liability in risky business ventures. So are there cases that I should look at that support that entrepreneurial idea?
Judge, I believe there are cases that support that. I think that they're cited in Judge Agostini's decision. I do not have those in case citations handy.
Counsel, are these Massachusetts corporations?
No, they are not. They were foreign corporations, Your Honor.
Okay, so any
I think they were. I
interest
think
we
they may have been
have-
Texas. I'm sorry, Judge.
Counsel, any interests that Massachusetts may have in protecting its corporate rules as regard to piercing the corporate veil would be inapplicable here if these are Israeli corporations, right? They're formed under Israeli law, and Israeli law would govern them. So I don't see a matter of public policy for Massachusetts to enforce its corporate veil piercing rules to Israeli corporations. Do you agree with that?
I agree, but and I'm not. I don't mean to correct Your Honor, Justice, but I believe that what we call the Bandle entities, whoever they were called the Bandle group, but the Bandle entities, I believe, were foreign corporations. I'm going to remember, and if my brother wants to correct me, I think it was from the state of Texas, because in the record, I think Judge Agostini makes reference to the fact that there was a bankruptcy proceeding that was filed subsequent to the exploration not being successful. And that bankruptcy took place in the state of Texas. But I think Your Honor is right that we are not looking to protect Massachusetts corporations in this particular case. This is purely.
Nonetheless, we can look at this issue under the repugnancy clause, cognizant that Judge Agostini made a finding that Ms. Diamond agreed that she would pay the bill, but we can still consider the whole corporate veil under the repugnancy clause, can't we?
I think that that's the argument that my brother makes, and I don't think there's anything preventing the court from using that analysis. I mean, that's what we look to the court for, to make that determination. We don't think it was repugnant because of the fact that that Amy Diamond agreed in the fee agreement is clear that the relationship is governed by the laws of the state of Israel, as opposed to any other forum. And I believe that Judge Agostini decided that she was bound by that determination. So I don't think Judge Agostini was inclined to sort of trample on Israel's law. And I think he also was impressed by the fact, when I say impressed, I use that with a lowercase I. I think that he was satisfied by the fact that Israel takes the idea of piercing the corporate veil seriously, that it wasn't just lightly done. And I think that was based on the testimony of Shmuel Cassouto. Keep in mind that there was no expert testimony or any other testimony. Nobody brought in any contrary evidence at trial on this particular point, on these factual findings. And I think that that's a factual finding. It could be a legal finding, but I think for purposes of this, it's a factual finding where he made the determination that Israel takes the law of piercing the corporate veil seriously. I mean, it's a sophisticated legal system that they have over there. This wasn't done arbitrarily or on a whim.
Are there any other questions?
No, thank you, Chief.
Okay, thank you so much.
Thank you.
Thank you, Council.